the credit of this session and the conceptualization of this session clearly goes to Nick Peacock, because when this new LCIA rules came in, we were discussing the implications, and when I was communicating with him, the idea propped up that why don't we do something around India UK corridor for several reasons. One, of course, the trade and the commerce between these two countries is going to see a very different trend going forward. The disputes arena also would change with COVID. Obviously, a lot of the dispute work, the proceedings, the way they are conducted, the manner in which clients expect the services, everything has changed. So we thought, why don't we have a fresh look on this whole aspect? And that is where Nick and NDA thought, don't we look at this and do a webinar? So looks like it was a good decision. We have more than 300 participants on this webinar, and when we floated this idea with LCIA and UKIBC, they readily accepted it. So thank you, Kevin, and thank you, Wing, for getting on board on this idea, and thanks Karan and Nick for co-hosting this along with NDA, UKIBC, and LCIA. So with that background to the session, let me introduce you to the panel which we have today. We have Wing Sheikh. She is a senior counsel at the LCIA UK, as well as the acting registrar of LCIA India. She supervises the Asia, CIS, and Russia LCIA casework team, as well as managing LCIA India arbitrations. So we will hear her quite a bit today on the new LCIA rules as we go along on this webinar. We also have Kevin Mccall. Kevin is Managing Director at the UK India Business Council. He leads the advocacy, advisory, membership, communications, and research teams at UKIBC. And thanks, Kevin, for joining this session. I know you are also very active on the UK India CEO Forum, which reports directly to the Prime Ministers of both the countries, and the UK India Joint Economic and Trade Committee, which reports to the UK's Secretary of State for International Trade and India's Minister of Commerce and Industry. So we will, of course, hear from you as to where the India-UK business corridor stands today. What do we expect in next 3 to 5 years, and how the other external conditions are, shaping up that thought process. We also have Nicholas Peacock. He is a partner in the Herbert Smith Freehills London office. He's the head of HSF's India International Arbitration Practice, and also sits on executive committee. I know Nick since his days in Singapore and then UK for over 10-12 years now. He has his career over 20 years into this space, and is a very, very well regarded and a successful commercial disputes lawyer internationally. We also have his colleague Karan Talwar. He is a dual qualified solicitor from England and Wales and India, and he is part of the London dispute resolution team and focuses on complex energy structure and engineering disputes. So with those introductions, let me straight away go into topics. Before that, of course, I would like to introduce my colleagues, Payal Chatterjee, who heads our European practice. She's based out of Mumbai, but once things ease off so far as Corona, COVID issues are concerned, she will also spend a lot of time in our Munich office in 2021. And we also have Alipak Banerjee, who is a senior member of our practice doing dispute resolution and investigation. He's our Delhi office. So with those introductions, let me straight away go to Kevin. An idea is to broadly understand where India-UK business corridor stands today. Post-Brexit, during COVID, the other considerations which are relevant for the business corridor, while India and UK have been trade partners for a long time now, and UK has always been top 3, top 5 foreign direct investments so far as India is concerned. So, Kevin, where do you see this going? Particularly London as a favorable destination for India and vice versa. And what are the proposals at the moment, whatever is in the public domain that you can share with this group?
Okay, thank you, Vapak, for the introduction and for the invitation to speak today. And thank you to Herbert Smith Freehills for involving me too. I think I will avoid using the words COVID and Brexit, but they are very relevant to the remarks that I'll share with everyone today. So I'm Kevin Mccall. I'm a Managing Director at the UK India Business Council. I've been working for the UK IBC for the last 12 years. And for the 3 years immediately before that, I was working in India, in Kolkata, for the British Deputy High Commission there. So I've been working on the UK-India bilateral relationship for the last 15 years. Now, it's not always been easy or necessarily fun, but it's absolutely never boring. It's a fascinating and thoroughly enjoyable corridor in which to work. I'm a great believer that despite short-term bumps and dips, COVID and Brexit, there I've said them, most things get better over time. And this is certainly the case for the UK-India trade and investment relationship that I've seen over the last 15 years. Right now, despite the COVID-19 crisis, the relationship is strong. It's as strong as ever. And in my view, it's about to take a step change in a positive direction. And I'll come to that future in a moment, but I want to set the scene with a few headline facts and figures in terms of the trade and the investment relationship. First, let's take a look at the trading relationship using some statistics drawn from the UK's Office for National Statistics. So in the 4 quarters to the end of March 2020, total UK exports to India were nearly £8 billion. Disappointingly, that's a decrease of 6.6% of about £550 million compared to the previous 12 months. So that's not good. But in the same period, the total Indian exports to the UK were £16 billion, just over £16 billion. And encouragingly, that's a big increase of over 23%, or £3 billion more than the previous 12-month period. So overall, bilateral trade was about 24 billion last year, up 2.6 billion year on year, India being the beneficiary of that those trade flows. It's not bad performance, but it's commonly acknowledged that the UK-India trading relationship could be a lot better. On the other hand, the bilateral investment relationship is hugely impressive. Some figures drawn from DPIIT, the Office of National Statistics, and reports produced by Grant Thornton and the Confederation of British Industries help describe that really positive relationship. So the UK is the fastest growing G20, UK has been the second, I have to admit it, the second fastest growing G20 investor in India over the last decade. The stock of UK FDI in India is rising year on year, and it stood at over £14.5 billion in 2018. There are over 400 UK companies in India, employing nearly 500,000 people in India. Looking at India into the UK, after the US, India was the largest foreign investor into the UK in 2019. The stock of FDI from India into the UK is rising year on year, and it stood at 14.5 billion in 2018. It stood at 11.3 billion in 2018, getting my stats muddled there. There are about 850 Indian companies in the UK, and they employ around 110,000 people. So the bilateral investment relationship is really strong, and it's getting stronger. And there's been two notable investments from India into the UK over the last 6 months since COVID struck us. One of them, not huge in terms of value, but TVS Motors acquired Norton Motorcycles earlier this year. And then Bharti Global partnered with the UK government to acquire the satellite company OneWeb. Now, what's common between these two investments is that they feature advanced technologies and or a renowned brand. Norton Motorcycles is a globally recognised prestige global brand. And this pattern, technology and brands, has been evident over the last 15 years or so, from the acquisitions of Tetley Tea, Typhoo Tea, Jaguar Land Rover, Hamleys, the toy shop, acquired by Reliance Retail, and indeed Bharti's investment in the Glen Eagles Resort in Scotland, an iconic resort and an iconic golfing destination. There's also an often unnoticed dimension to the Indian investment activity in the UK. And that's the presence of family offices in London that are looking for and taking investment opportunities in the UK. And there are many more top Indian promoters that have got family homes in London, spend much of the summer in London. And of course, there's a large Indian diaspora in the UK, and it's a successful and very influential diaspora. If you look around the cabinet table in the UK, our finance minister, our chancellor is of Indian origin, our home minister is of Indian origin, and the business minister, again, of Indian origin. And given this familiarity that Indian promoters and business leaders have with the UK, it's interesting that there's a concerted effort by these business leaders for the UK government to change its rules to facilitate the re-domiciliation of headquarters so that more of them can make London their home. I'd now like to move from those sort of trade and investment facts and figures and the dynamics to look at some of the government to government, some of the policy initiatives that I think will lead to the step change in the UK-India economic relationship. Now, the main bilateral trade dialogue is the Joint Economic and Trade Committee, JETCO, which is chaired, as was mentioned earlier, by the Indian Commerce Minister, Mr. Goyal, and his UK counterpart, Liz Truss. The UK IBC run the secretariat for JETCO, so we're closely involved in the activities. Now, when the ministers met for JETCO in July, they announced that they would be initiating, and I'm going to quote here, they're going to initiate an enhanced trade partnership, free trade agreement in India. Now, that's really exciting development there. And since that meeting in July, Junior Ministers Ranil Jayawardena from the UK and Hardeep Singh Puri from India have met twice. They met earlier this week, virtually, of course, to work on the details and move that enhanced trade partnership from rhetoric to reality. It's been interesting that, again, since July, the Government of India have been publicly bullish about an early harvest trade deal during 2021. Now, I would not rule that out, but neither am I holding my breath that that will actually happen. Fingers crossed, but these things are often more complicated than we want them to be. I really feel that this enhanced trade partnership has really got to be welcomed by businesses on both sides, not just because it will set out a roadmap to an FTA, but it's going to keep, importantly, looking at short-term issues and try and address some of those market access barriers and improve the ease of doing business in both countries so that things can improve before an FTA is actually concluded. The four ministers, Goyal, Truss, Singh Puri and Jayawardena, are planning to meet again in November, the second week of November, to finalise what's going to be in this enhanced trade partnership. So we'll need to wait another 3-4 weeks to get the full details. But what we do know is that the governments will establish a specific dialogue to explore routes to removing tariffs, trade tariffs, and also looking at those non-tariff barriers like intellectual property and standards. As well as this enhanced trade partnership, I think we should also look out for the governments to begin a dialogue on a UK-India bilateral investment treaty. So something that I think will impact arbitration in the future. Now, as you know, India unilaterally withdrew from its existing BITs in December 2016. So it would be important that the UK and India focus on establishing a new treaty covering investments. Another driver I think will really support the investment relationship is one that's more of an interpersonal one. You know, earlier this year, the UK government appointed Jerry Grimstone as a Minister for Investment. Now, Jerry, now Lord Grimstone, is a very close friend of India. He established the HDFC Standard Life JV when he was chair of Standard Life. And he was also chair of the UK-India CEO Forum and the India-UK Financial Partnership. So he's deeply connected to India, and I think that can only be a good thing for the UK-India investment relationship. So just winding up in summary, bilateral trade and investment flows are increasing, particularly Indian exports to the UK and Indian investments into the UK. London is and will remain a hub for that activity, not least because it's a second home for Indian business leaders and the base for their family offices. And I anticipate these flows will increase. In the last 6 months, the government-to-government connections have had much greater purpose than I've seen over the last 15 years. It feels like there's a real political will to reform, to quickly remove technical barriers to trade, to look at tariffs, and to work on bilateral agreements. Real step forward, and things that have only become possible in the main because the UK has left the EU. So I've mentioned Brexit. There we are. So
Sure.
I'm confident about the future, and I'm certain that the role of London as a financial and legal hub is only going to grow and grow and grow. I will stop there and hand over to my esteemed lawyer friends to take the discussion forward. Thank you.
Sure. Thanks, Kevin. Thanks for the India business corridor stands today. I think it's very, very promising. A lot of stuff is happening at the highest government level, and it only assures us that as we move forward, this corridor is only going to get busier, and which means that while disputes is never in anybody's mind when they are talking about business, but somehow it goes hand in hand, and possibly that's where Nick and Karan also comes in from London as a hub for India related dispute resolution, and how can we take that flag higher. So we have seen, maybe if I can bring Nick and Karan both, depending upon how they want to address this issue. But we have seen the whole cycle of India related disputes in last 3-4 decades. We have seen at some point in time ICC and LCIA were the most preferred institutions for international disputes, and considered to be the most independent and fair seats, and one of them was obviously London. Then in the early 2000 and later, I think some of the Asian jurisdictions like Singapore and thereafter Hong Kong, and then now even AIAC, they have become prominent so far as India related disputes are concerned. While ICC and LCIA also continues to hold their dominance on some of those disputes as well. But more than the institutions, I think London as a seat and legal advice and the kind of jurisprudence which it provides has a very different edge in terms of dispute resolution. So maybe Nick, if you can come in first. How do you?
Sure. Well, look, thanks, Vyapak. Thank you, first of all, for hosting this session, which, as you say, was one that we discussed and I think is very relevant from both ends of the UK-India corridor. Thank you also to Kevin and Wing for joining us and contributing. I think Kevin's non-legal viewpoint is a particularly good backdrop for this discussion. Clearly, with so much trade and investment going down that UK-India corridor, it is no surprise that there's also an active legal corridor, and part of that, of course, is in relation to dispute resolution. And London, despite, as you say, the growth of disputes being heard in other centres, and certainly I've seen the growth in Singapore, and I was part of that market for a number of years. We see growth in Hong Kong as well, especially once that became a notified jurisdiction under the Indian Arbitration Act. Malaysia, as you say, KL is also a good centre for India-related disputes. So we've seen growth in those, but I still see a very busy and active dispute resolution centre here in London, both from international firms like myself, also from Indian practitioners, and a number of Indian senior advocates have chosen to take up places at chambers in London and elsewhere. I just thought I'd start off by giving a few thoughts on the dispute resolution landscape in London for those who are perhaps less familiar with it. Just in broad terms, and without going into too much detail, the default mode of dispute resolution in the UK, as in India, is the court system. The civil court system consists of a number of specialist tribunals who deal with things like employment, competition law, then county courts and high courts. And the high court is where practitioners such as myself tend to operate on larger commercial disputes. Even within the High Court, you have separate divisions and benches dealing with technology construction, bankruptcy and the like, but we'll not go into all those divisions now. The High Court tends to be where those commercial disputes get played out. The appellate courts are, of course, there. We have the Court of Appeal and we have the Supreme Court, which older practitioners might remember as the House of Lords. You need permission under the English system to appeal to either the Court of Appeal or the Supreme Court. Unlike in India, you will very rarely find yourself in the Supreme Court on a commercial matter. The Supreme Court chooses its own cases and is very picky about how many and what commercial case it takes over the course of a year. Important point on costs. The general rule is that costs in English litigation will follow the event. So the losing party will bear the costs of the successful party. Perhaps not penny for penny, but certainly something like 2/3 or 3/4 of actual legal costs. So the loser pays regime is very significant. ADR, alternative dispute resolution, is actively encouraged within the English court system, both by the court rules and by the judges themselves. Mediation has been a key component of court litigation for the last 20 years in the UK. And parties who unreasonably fail to mediate can and are sanctioned in costs by vigilant judges. So you will often find yourself in English litigation explaining to a judge why you are not ready to mediate yet, why later is a better time, or agreeing to go off and have a go at mediation. More generally, parties are encouraged to ventilate issues in disputes early. We have pre-action protocols to try and get the crux of disputes on the record early. And there are also various incentives for parties to make off-the-record offers to settle. And again, if you make an off-the-record offer which is not accepted by the other party and you do better than that at trial, then the other party is likely to find itself penalising costs. So there are lots of levers, mostly around costs, that can be used to try and encourage parties to settle and behave reasonably rather than going to trial. One issue of the English court jurisdiction that proves particularly popular for some litigants is the ability to ask for urgent interim measures in support of litigation or indeed pending arbitration. A worldwide freezing order is indeed a very powerful weapon, especially when you're dealing with suspected fraud and the dissipation of assets. Other injunctive relief is also available, such as preserving assets or a contractual status quo pending main proceedings. Alongside, of course, court litigation, of course, there's a lot of commercial arbitration. The arbitration market in London is a healthy mix of ad hoc arbitration and institutional arbitration. Of course, the ad hoc stuff tends to go under the radar a little bit. It's harder to gauge. We did review Last year, the statistics for the London Maritime Arbitrators Association, which has a good insight into a lot of the ad hoc arbitration going on in London. And that confirmed that ad hoc arbitration remains a popular choice, especially in certain sectors. So shipping, commodities and construction, there's a lot of ad hoc arbitration. Otherwise, there is heavy use of institutional arbitration. Institutions such as the LCIA and the ICC, as mentioned by Vyapak. And on the whole, these institutional arbitrations are very efficiently and swiftly conducted. You're looking at an average of 12 to 24 months in the majority of commercial cases. The LCIA itself conducted some analysis a couple of years ago, which showed that the median duration and costs of its LCI arbitrations remained relatively low. So the median duration is about 16 months, and the median costs is around 97,000 US dollars, which of course is depends on the size of your dispute, but across a caseload of some very big and very high value disputes, it shows that it's relatively efficient. Awards tend to come out within about 3 months of the final hearing, which shows the arbitrators are being diligent in performing their side of the tasks. Most arbitration awards in the London market are satisfied without being challenged. So you don't end up in court for most of these awards. When you do find yourself in court, the judges are very robust in dealing with them. So any attempt to delay enforcement through challenge doesn't tend to last very long. That was just what I wanted to say in terms of the disputes landscape. I'm going to pass on to Karen, who's going to just say a little bit about some of the notable cases we've seen involving Indian parties in particular.
Thank you for that, Nick. So on that topic, so we know that a lot of media attention has recently been focused on the ongoing extradition cases with Nirav Modi and Vijay Mallya. But in that time, I think we have continued to see some really significant India-related disputes in the UK. So what I intend to do is just run through a few examples to give the audience a flavor of the kind of cases that we tend to see. On the arbitration front, we've seen a recent arbitration involving Indigo. So one of the co-promoters of Indigo has filed LCIA proceedings against the other co-promoter, both of whom are majority shareholders in the airline. The dispute is about the size and composition of the new Indigo board. So that's a dispute that has potential ramifications for the airline going forwards. We've also seen a second dispute coming out of Cairns' 70% stake in the Barmer oil block in Rajasthan. So Cairn has filed those proceedings, and they're contesting a claim for additional profit by the Indian government for about $500 million US. So that could be quite an interesting one. Some members of the audience might also be familiar with the arbitration that took place a few years ago between Tata Sons and NTT Docomo. So as you may remember, Docomo won that arbitration, and the tribunal ordered Tata to buy out Docomo's stake for about $1.2 billion US. On the litigation front, we recently saw a challenge by the Indian government against the 2018 award passed in favor of Reliance and Shell. So the award relates to PSCs for oil and gas fields off the coast of Mumbai. And like Nick mentioned just a few moments ago, challenges to awards are quite difficult to maintain in the UK. And indeed, in this case, the government was unsuccessful and they could not put that award to one side. So just finally on this, I should also mention that HSF, of course, continues to work for Indian clients on disputes in London. We recently acted a few years ago for Vedanta in a high court litigation involving a class action from Zambia. And I know that Nick is working on and continues to work on some cases that are not quite public yet. So all in all, I would say that we continue to see some really interesting, significant cases in London involving Indian parties.
Yeah, thanks, Nick and Karan, on giving a picture on the two countries, particularly from London perspective. So let me bring in Alipak here. He looks at quite a bit of India UK disputes at our firm. He's also qualified in UK. So in fact, he has spent some time in London working with few firms there. So what is your take, Alipak? Are you seeing a very different perspective, considering the Asian onslaught? Are you seeing London, regaining its spot where it was? And with the new LCIA rules, and also the kind of business that you will see between these two countries, what do you expect going forward?
Thanks, Vyapak. Yes, India-UK corridor has been very busy. I think in the last 5 or 7 years, we have seen a lot of cases, and Karan very helpfully pointed out a few examples. And maybe I'll add a couple of a bit more. But let's take this discussion a bit more. I think why do we go back to London? That's the first question I ask myself. I think the discussion point starts with the kind of cases we rely in our courts, right? Our legal system is very, very similar to what is there in UK, and large part of it is borrowed. So Indian parties, they feel that the UK, or in particular London, is very familiar in terms of the judicial mindset over there, the expertise of the judges, and also I'm told that there are more than 700 law firms in the UK, and the barristers and the Queen's Counsel that we get there, which is why London inevitably gets triggered in any dispute that we do, be it in Singapore, be it in Hong Kong. There's always a London angle to it. Now, to be more specific, in early 2000 or maybe till up to 2010, 2011, we saw a lot of dispute resolution clauses with London as a seat of arbitration. It continues even today, primarily in large value contracts originating from Europe or in US. The Asian traction that we see as regards Singapore, Hong Kong, that is a lot of it deals with contracts with Japan or other Asian countries. But still, my view is that many large contracts which involve billions of dollars, and if the counterparty is European or in the US, we still put the London as a seat of arbitration. I'll come to the institution part in a minute, because that discussion is slightly different. Now, the recent examples of high-value disputes, Karan very helpfully pointed out a few. There was another case called Vikram Bakshi and the famous McDonald's dispute, which related to exit rights. That also was in London, LCIA seated arbitration. In fact, both Tata Docomo and Vikram Bakshi, both these cases settled eventually in India at the enforcement stage. Indeed, there are existing matters going on. Karan mentioned Indigo, and there are a few others as well. We are also working on one or two, but nothing is in public domain, so we will not be able to name them. But it continues to be a very busy sector. Why do people choose London as the seat of arbitration? I think the obvious advantage that it grants in terms of the curial law. The courts are very sophisticated. Nick mentioned that you lose a case and then costs get awarded. 75 to 80% of the costs can get awarded. The judges are really good. There's very narrow scope of challenge under the UK Arbitration Act, Section 67, 68, and 69. More likely than not, you will never succeed. Well, I must also add over here, even in India, we have also, in the earlier days, the awards used to get nullified, but in the last 4 or 5 years, even in India, we have done really good. Awards are not set aside, but having said that, we of course look up to the UK courts for that. And UK as a jurisdiction, London as a jurisdiction is known for arbitration-friendly approach. In addition to that, I think even if the arbitration is seated somewhere else, for example in Singapore, inevitably we will instruct a UK firm or a solicitor or a Queen's Counsel for the purposes of argument. So there is that London link which automatically comes. Now next, let's take the example of a few court cases in London. As Nick rightly pointed out, UK courts are known for awarding freezing injunctions, which can be a very effective tool in running the arbitration. So we have seen a lot of cases where Indian parties have filed for freezing injunction in London. Even otherwise, as Karan was also mentioning, the Indian banks are after a lot of offenders who are now residing in London. chasing for millions and millions of dollars of money, and it's all there in public. Some cases, there are some cases where people are trying to extradite the people from London. So these are obviously cases in London which are going on. The other point which I would like to mention is that India and UK, they have reciprocal arrangement in terms of enforcement of foreign judgments as well. So India has reciprocity with 13 countries and UK is one of them. So a judgment passed by a UK court can get enforced in India. You don't need to file a separate petition in India from the scratch. The foreign judgment is you basically file an enforcement petition, and the grounds for refusal is very narrow. Natural justice or the usual grounds are there. But then, in our experience, we see maybe in 3 or 6 months, foreign judgments get enforced. Arbitral award, well, of course, India and UK under the Indian Arbitration Act, they have a reciprocal arrangement. You could enforce an UK-seated arbitration award in, say, 6 months to 8 months. There are settled case laws in India right now that while you're trying to enforce the arbitral award, you don't have the right to challenge. You only have the right to resist enforcement, and that plays a very important role. You can't argue on merit. It takes about 6 to 8 months, and increasingly we are seeing a lot of cases where even costs are getting awarded. So these developments, in my view, has sort of added to the dominance of London in terms of the global dispute hub, and the parties are increasingly choosing that. Now, in terms of institution, a quick point, yes, we have seen a lot of traction for CIAC in Singapore in the last 5 to 7 years, but in a lot of high-value disputes, sometimes parties may find that LCIA may be more cost-effective because they would charge you based on the efforts put in by the arbitrators and not on the basis of the value of the dispute. And in our experience, we have seen a fair bit of large, high-ticket, high-value disputes being governed by LCIA arbitration, and that continues even today as we speak. So that was my preliminary thought, and then happy to answer any specific questions.
Yeah. Thanks. You ended up with the institution point, and that's the right time for to bring Wing and her perspective on LCIA and how LCIA looks at India now, considering they originally also had an LCIA India chapter as well. But recently, LCIA also published their 2020 amended rules, bringing in quite a bit of changes to their existing LCIA rules. So maybe what was the objective behind it? What was the thought process going into those amendments? And how do you see those rules now shaping up the London as a seat and LCIA as a preferred institution? Maybe Wing, if you want to come in at this time and give your perspective on that.
Thank you. I just want to say thank you for inviting me. I'm really happy to join the webinar today. Just by way of introduction and distinguishing between LCIA and LCIA India, LCIA is one of the leading institutions for international commercial dispute resolution, with its origins going back to 1892. And we provide arbitration and ADR services, as well as a membership program and organize conferences in all regions. And LCIA India was opened in 2009 to offer arbitration and ADR services for users in India. And while there was some initial uptake, it became apparent that Indian users were content to use the LCIA rules, and LCIA concluded that it would better serve the Indian market from London rather than have a separate offering. So whilst we are currently still administering from London cases under the LCIA India rules, where the arbitration agreement is made before the 1st of June 2016, we're not providing from LCIA India services beyond this. And from London, we will be administering cases for Indian users. Moving on to the LCIA rules, I thought I would highlight some key provisions of LCIA arbitration rules first before moving on to the highlights of the updates, because the updates build on the success of the 2014 rules, which have been in use for some time. One unique tool under the LCIA rules is the possibility of expediting the appointment of the tribunal. So we already appoint the tribunal quite early on in the proceedings, as the court is obliged to appoint promptly after receipt of the response, which is within 28 days of the request. So in cases of exceptional urgency, parties can apply for the appointment of the tribunal even earlier than this usual timeframe. And if the application is granted, the court can appoint as quickly as in 1 or 2 days. Like other leading institutions, we also have emergency arbitrator provisions, which allow for the appointment of a temporary sole arbitrator to decide on urgent interim relief. The default position under the rules is for the court to select the sole arbitrator and tribunal members, but parties can, of course, agree nominations. And before the appointment, all candidates are required to confirm to the LCIA court that they are independent and impartial of the parties, as well as being able to devote sufficient time to ensure the expeditious conduct of the arbitration. Overall, the rules allow for flexibility and encourage parties to agree the procedure for the approval of the tribunal. And following the appointment of the tribunal, the rules also provide the tools to ensure the efficient conduct and progress of the arbitration. For example, after the appointment of the tribunal, the parties are to make contact within 21 days. Also, at the other end of the proceeding, the final award must be made as soon as reasonably possible after the last submission, and the tribunal is obliged to inform the parties of when it has scheduled time for deliberations, as well as the timetable for the award. And the 2020 update includes a 3-month endeavour to timeframe for the tribunal to make the award. So this is not a strict deadline, recognising that some awards take less time and some awards may take longer. The rules permit the consolidation of arbitrations under certain circumstances. Firstly, where there is party agreement, and secondly, where the parties are the same and the arbitration agreement is the same or compatible. These circumstances have been broadened in the 2020 update to include where the arbitration agreements are the same or compatible and either arising out of the same transaction or a series of related transactions. The court also has the power to consolidate arbitrations in circumstances which were more limited under the 2014 rules, but which are now more aligned with the tribunal's powers under the 2020 rules. So we have an efficient challenge procedure, and the court will provide reasoned decisions. The LCIA was the first institution to publish anonymized extracts of challenge decisions, which can be found on our website. The LCIA was also the first institution to introduce in our rules ethical guidelines for legal representatives in arbitrations. These remain in place after the 2020 update, and in fact, the 2020 update to the guidelines extends the application to party representatives. As mentioned by Alapak, we have an hourly rate system for the tribunal and the secretariat. We have a capped maximum hourly rate for arbitrators, which is £500 under the new schedule of costs, which caters for the more complex cases, but the court can set a lower rate for less complex cases. Advances for costs are directed in stages rather than directing the full amount up front. And this way, the estimates that we have are more accurate, and we're not asking for more money than is required at the time. And the costs are determined and controlled by the LCIA court which scrutinizes and reviews detailed fee notes from arbitrators. So moving on to the specific updates in the 2020 rules, rather than being an overhaul of the 2014 rules, the 2020 updates focus on clarifying certain tribunal powers, increasing efficiency, and reflecting the evolving nature of the arbitrations. So starting with the last aspect, a major change has been a shift to the primacy of electronic communications. So this means that filings of requests, responses, and all communications will be made electronically unless otherwise ordered by the tribunal or the registrar. The updated rules permit awards to be signed electronically and/or in counterparts, reflecting modern practices. The 2014 rules did permit electronic transmission of awards, but the equivalent provision in the 2020 rules specifies that awards will be issued by electronic means only, unless a party requests a paper award or electronic transmission is not possible. We have also included in the rules references to video conferencing and the use of technology. These changes are reflective of the modern ways in which we're working and which have been accelerated by the pandemic, as well as the increased global emphasis on being more eco-friendly. On efficiency, the 2020 updates have new provisions to permit what we call a composite request and response to be filed. This means that the claimant can now commence more than one arbitration with a single request for arbitration. And this is intended to allow the parties the flexibility and convenience when they want to commence multiple arbitrations. A composite request is also envisaged for cases where parties wish to apply for consolidation or concurrent proceedings. The respondent or respondents may then also submit a composite response, but are not required to. As I've already mentioned, the tribunal's powers to consolidate have been broadened, as have the court's powers. This means that those who have multi-party and multi-contract disputes have greater options to have their disputes dealt with by the same tribunal and in one proceeding, which has cost benefits as well as efficiencies. So the tribunal now also has the express power to order concurrent conduct of proceedings, although in practice, some tribunals are already running cases concurrently. Any order of the tribunal for consolidation and concurrent proceedings are subject to the LCIA court's approvals. Under the rules, the tribunal's procedural powers have also been enhanced. There are provisions focusing on expediting procedures where appropriate. The rules encourage parties to agree joint proposals, but strengthened provisions also give the tribunal a discretion to make any procedural order it considers appropriate, bearing in mind its duty to ensure the fair, efficient, and expeditious conduct of the arbitration. And the rules now give a non-exhaustive list of ways in which the tribunal may discharge this duty to expedite the proceedings, such as limiting the length of written statements and oral testimony, employing technology at any stage of the proceedings. For example, this might include document management, software, or virtual hearing platforms. The tribunal may also bridge timescales, dispense with a hearing if a party has not requested one, and make an early determination that any claim, defense, counterclaim, cross-claim, defense to counterclaim, or defense to cross-claim is manifestly outside the jurisdiction of the tribunal or is inadmissible or manifestly without merit, and where appropriate, the tribunal can issue an order to this effect. In practice, we were seeing tribunals already using some of these powers under the 2014 rules to conduct arbitrations efficiently, but the updates now expressly confirm these powers and can allow tribunals to be more robust when they're setting procedures, especially at an early stage. In terms of how these provisions may impact Indian parties, I think they will really help facilitate a move towards paperless arbitrations, using technology where appropriate, and streamlining procedures, which is particularly relevant if there are domestic arbitrations and timescales are relevant under the Act. The primacy of electronic communications means that filings will be quicker and awards can be issued in a more efficient way. And tribunals will be able to sign awards electronically without being concerned about circulating signature pages during this COVID times when we need to socially distance ourselves or self-isolate. And there is still the possibility for parties to communicate by electronic means if that's required in the jurisdiction or a contractual provision requires it. Another major impact on arbitrations when the pandemics started, on where different countries were in lockdown, was the delay of hearings, and we were seeing tribunals being reluctant at first to progress arbitrations or to hold virtual hearings. And the confirmation in the rules that hearings can take different forms, including virtual and be remote, and be in different geographical places, but still be treated as being conducted in the arbitral seat, really will help to facilitate these hearings to take place. And this has been particularly important to reduce delays caused by the pandemic in resolving the disputes quickly. And hand in hand with these updates, we've seen all the innovative work that has gone into the new protocols to address concerns about due process in virtual hearings to make sure that they're being held in a fair and impartial manner. One aspect of the 2020 update I haven't yet mentioned is about confidentiality. So the 2019 amendments to the Indian Act introduced a duty of confidentiality applying to the institution, the parties, and the tribunal, which I think some considered did not go far enough. And the 2020 update on the confidentiality provisions go beyond the Act to include other participants in the arbitration, such as tribunal secretaries, witnesses, experts, and service providers, with the onus being placed on the parties to seek this undertaking from the participants. And finally, with the new emphasis on technology, parties should address with the tribunal at an early stage security, cybersecurity, and the 2020 rules recognize and encourage this. Again, these changes are reflecting the current needs and best practice for all participants in the arbitration. Thank you.
Yeah, sure. Thanks a lot. Analysis on the amended rules, and I'm sure this will help the participants in understanding that these are now most updated in terms of things like confidentiality, consolidation, disclosure, independence, and stuff like that. So I think that's very, very helpful. 2 or 3 things that you talked about, which obviously relates to the current state of the world, which is the pandemic and the repercussions around it, which is the electronic communications and virtual hearings. So let me take that point little further on and bring in Nick and Karan back on that issue as to what is their experience since the March of 2020 when this pandemic sets in. as to how do you see the legal industry, the lawyers, the clients, the arbitrators, taking up this challenge? Are you seeing it becoming a new normal? Are you seeing this going forward irrespective of COVID? What's your take on this?
Thanks, Vyapak. Karen, why don't you make a few comments on the courts, and then I'll chip in on arbitration.
Of course, Nick. Thank you. In terms of how the courts have responded to COVID, I think as a starting point, as one would expect, the courts have been very proactive. So we've recently seen all sorts of guidance notes and protocols from the court on how virtual hearings should be conducted. The default position now is that hearings will be conducted with either one, more than one, or all participants attending remotely. We're also seeing very strong evidence that courts are trying to increase the use of technology rather than get to a stage where they have to reschedule hearings. There's also a few trends that we're now seeing anecdotally. I think first we're seeing that the courts are quite flexible in the use of hybrid hearings, where you have attendees in person but also partly remotely. We're seeing some preference for certain technology platforms over others. So, for example, Skype seems to be used quite often with the UK courts. And of course, hearings are being broadcast as per normal, but the courts do have the discretion to have them privately if that's required for the administration of justice. There were also some interesting comments that came out from a meeting that was held earlier this year. So this is a commercial court user group meeting. And I just wanted to mention a few quick points on that. So the judges that participated in that commercial court meeting themselves felt that the transition to virtual hearings had been smooth. When that meeting took place, the judges had only seen 4 instances where a virtual hearing was not feasible because of poor internet or the witnesses being ill and so on and so forth. But other than that, it had been quite smooth. Interestingly, they also said that there had been no fall-off in court business, but in fact, there had been a slight upturn in the actions commenced, at least at that stage. So I think the very short summary is that the courts have been very proactive. They've been flexible. It is largely business as usual. And I think it's fair to say that the courts are not only just restricting themselves to urgent cases, but they're trying very hard to keep it business as usual.
Thanks, Karen. Well, I think we've all surprised each other and ourselves at how we've been able to switch to virtual business. And I think that's true of the courts, certainly in London, and also true in arbitration as well, where I think the response has been similarly impressive. And it's more or less business as usual in terms of London arbitrations. In-person hearings have become virtual hearings. And of course, we've all got very comfortable on the various platforms we use. I think, as Wing mentioned, we did see a few in-person hearings getting adjourned in the spring. I think when there was a hope that the lockdown might be a temporary measure, I think some tribunals did think that a full hearing that was going to happen in the spring may as well wait until the autumn and it would happen in person. Now that the restrictions are ongoing, and since, of course, everyone in the meantime has become expert on our various technology platforms, those hearings are now going ahead. We're not seeing second adjournments. I'm the director of the IDRC, the International Dispute Resolution Centre here in London, which is one of the main hearing venues. And the IDRC runs both physical hearings, now suitably distanced, barriered, and impeccably clean, and also runs virtual hearings, including running online bundles and transcripts. And it's fair to say, I think the book of hearings in the autumn is very healthy indeed, reflecting business as usual, autumn being a busy season for hearings anyway, a certain amount of postponed hearings from the spring that are now happening and going ahead. We have had some of those go ahead as in-person hearings. The government guidance at the moment is to work from home if you can. So some of those in-person hearings that were scheduled for this month have flipped now into virtual hearings. But it's fair to say the business is carrying on as it was. I think it's also fair to say that once we are through these temporary strangenesses, the future won't look the same as in the past. And I think, again, as Wing mentioned, the LCIA rules reflect that there's likely to be a new way of doing things, at least in part. Procedural hearings in many London arbitrations were not in-person hearings anyway. If you had a case management discussion with the arbitrator or the tribunal, you would often do that by telephone. I think now the default for that will very much be video conferencing of some kind. And I think also we're going to get better in the future at not needing everyone to be in the same room. I think counsel and the tribunal will always want to be in the same room if they can. I think main witnesses who are to be subject to lengthy evidence, it's always going to be helpful for tribunals to see them in person. But I suspect we will be better in future at expecting people who are of lesser significance to the hearing, not able to travel, or it's not, frankly, economically or ecologically sensible for them to travel for the role they have to play, will increasingly be allowed to attend virtually. So we'll have that hybrid hearing system that we're seeing now, I think is likely to be a feature in the future as well, which I think will be good in terms of efficiency and cost and time, and also a little bit in terms of the carbon output of the arbitration process. So I think overall, Vyapak, yeah, it's been a modest success story in London, I think, in terms of how effectively courts and arbitral tribunals and mediations, I should say, have flipped onto the virtual platforms.
Sure. So I think that from Indian perspective also, we have seen a very positive response, at least from the senior courts, which is the Supreme Court and High Court, in coming up with solutions for virtual hearings. And also, I think even from the arbitration world, including the typically the arbitrators that we talk about in India, we thought it might take little longer to adopt the virtual hearings, but we have seen this pandemic has allowed us to transition into this very, very quickly. On this, maybe I'll bring in Payal on some of the updates on the actions taken by both Supreme Courts and various high courts in terms of supporting some of this virtual hearing, including the postponement of certain hearings, the limitation period, and so on and so forth. But just before that, there is one interesting question from Geoffrey. It says, is there much ad hoc arbitration in India or on Indian business in London? I think, at least from my perspective, the answer is yes. Seen few of those ad hoc arbitrations seated both ways in India and in London related to India business corridor. But Nick, if you have anything on that question, we can take it now and then we'll go to Payal.
Sure, yeah, look, I think it's a mix. There is ad hoc arbitration taking place in London on India-related matters. As I say, I think we see it most in certain sectors, in shipping, in trade, commodities trade in particular, and to some extent in construction. So certainly, yes, we've seen it, and I've been involved sitting as an arbitrator in an ad hoc hearing, which interestingly was an ad hoc arbitration. Then the parties agreed to appoint the LCIA as the appointing body and to hold the funds and administer the arbitration. So even then, I think the confidence and use of institutions in London is perhaps a little bit higher than it is in India.
Sure. And there is another question from Harish. Talks about the adoption of technology in dispute resolution since past 3 years, basically adopting the digital technology, AI using Internet of Things in infrastructure, construction, and energy disputes. Maybe Karan, if you have any quick take on that question from Harish, because we are talking about this this topic, and I thought that question is relevant.
Right. Yeah, so I think I have 2 quick points to mention there. So as I a lot of construction disputes, and as we know, construction disputes and energy disputes tend to be very fact and document heavy. So there's increasingly a use of different platforms that help solicitors prepare their case. So there's platforms that help you put together the hearing bundles, there's various technology that's now evolving that helps with disclosure exercises. So tracking through documents that are, you track through a wide pool of documents, and then you try to narrow it down to those that are relevant to the issues that you have in dispute. So there's been a lot of development there, and I think most firms in the UK are at a stage where they're quite comfortable with using these new technologies. So it is very encouraging, and that's an area that continues to develop, and hopefully we'll see some more progress there.
Sure, thanks a lot. So getting Payal on this, particularly from an Indian perspective, Payal, how Indian courts and arbitration world, reacted to the pandemic. What are the things that we have already implemented in India, and how do you see this going forward?
Thank you, Vyapak. A very good afternoon and good evening to everyone joining us today. The last speaker on the panel today, I'm going to keep it brief. I understand it's already lunchtime in London. I would not like to come between lunch and people joining us from London over here. So I think going back to the litigation scenario, I think the take is very similar to what Karan mentioned. Obviously, I think the Indian legal industry jumped at the occasion. The Supreme Court, within a span of 2 days itself, started with video conferencing and virtual hearings, which it's not something that we never had in India, back in India. There was a lot of virtual hearings happening in Delhi High Court, but those were for certain category of matters itself. But with the pandemic coming in, I think the Supreme Court constituted an e-committee and ensured within a span of like 1 week's time itself, you actually have proper processes in place, you have platforms in place, which will ensure that you can continue with the hearing. Now, India obviously has been infamous for having almost 30 million pending cases. So there was a requirement to ensure that you have two major developments taking place. One was extending the limitation period, which ensures what? Basically that the legal rights of people which are going to be accrued during this period are protected. The second aspect of extension of interim relief. This was very critical and it has been continued till 31st of October this month. The reason being so that you don't have to rush to the courts. There are less amount of risk being taken. So you balance the situation both from a court point of view as well as from the health situation. Then the Supreme Court in the month of April came up with the standard protocols as well as various guidelines as to how the virtual hearings are to take place. It also put in place processes including the e-filings as well as your payment of court fees and a very important requirement, which is explaining why your case is important. A lot of times in Indian matters, what ends up happening in courts is you have 100 matters listed before a judge. It's not that every matter is going to be taken up on that particular day. Now with the virtual hearing in place, we see 25 matters listed, and those matters are listed not just based on urgency, but it's been further classified to say exceptional urgency. The Supreme Court went a step forward and also defined what are the kind of matters they are going to take up, which included matters related to ongoing pandemic situations, in relation to personal life and liberty, criminal matters. And I think this is where I'm going to bring in more than from a procedural perspective, our practical experiences. NDA has been fortunate to be involved in two different kinds of matters. One being actually representing a private airline, where one of the issues was how many seats can be occupied in the flights given the current situation with the aviation industry again. I think the best part of representing them in the client in the matter is earlier the process was you have to go spend a lot of time, you're going and briefing your counsels, the travel time which is incurred. Here, even it's one team who is just involved in the matter on the ground. Even if you're winning, losing, whatever the situation is, once the matter goes from an appeal to the High Court and then the Supreme Court, it's the same team which is involved no matter where you're sitting. So that helps a lot from a cost as well as from an efficiency perspective. And I think as Alipak had mentioned earlier, every dispute in India always has a London angle involved to it. Whether it be because of the subject matter or it be because of the seat of arbitration or a party. But there's another angle as well, where you can also have the counsel involved who is sitting in London. Now, there not being too much of a time difference as well, we were actually briefing Mr. Salve in one of the matters. And we kept coordinating with him and briefing him virtually and him attending all Supreme Court hearings from London. I think the virtual system has actually worked in favor of the litigants. Whether you're staying in one of the big cities or in remote areas, you have access to your lawyers and to the judicial system. So I think the Supreme Court took this opportunity, grabbed it, and has actually expedited the technological advancement in India. On the arbitration side, obviously, India, along with institutional arbitration, also has a lot of ad hoc arbitrations. So there was a thought process which was that there might be a tendency of the parties to delay their filings and come up with reasoning that we cannot make the filings because we do not have access to the documents, which in some cases can be true, and actually delay the proceedings and maybe wait for physical hearings to happen. That has led to an important question, I think, which is world over being debated as to whether there is a right to even a physical hearing in an arbitration. Now, the Indian Arbitration Act does not specifically recognize a right to that, but it does have a provision on oral hearings. So I think it puts the tribunal in a very tricky situation, has to exercise their discretion and be extremely cautious when they are passing the orders, if at all there is an objection from one end to not go ahead with virtual hearings. One of the matters which we dealt during the pandemic itself is where we were representing a foreign party, and it's the government which was on the other side, or government undertaking. I mean, the first impression everyone thought was maybe the government might not be keen to go ahead with it because they might not have access to documents. But surprisingly, in spite of it being an ad hoc arbitration, the matter went on actually very smoothly and seamlessly, with both parties actually being willing to continue the process during the entire pandemic which is going on. So I think that briefly summarizes from India, from a both litigation and arbitration perspective, that the entire approach is positive, and the idea is to go forward and adapt to the changing. Thank you, Vyapak.
Thanks, Payal, for that. Obviously, a positive outlook on that, and I also firmly believe that this is going to now continue as a normal or a new normal. So far as arbitration is concerned, and maybe even for court system, they will have an hybrid system going forward, because there is a lot of efficiency which is getting achieved through this process. Also, unlike London, where most of the activities in one city, for India there are at least 7 or 8 big cities where a lot of activity happens. And every time you move from one city to another, or the cases go to Supreme Court from Bombay to Delhi, and from other cities, you end up taking different lawyers and different counsels. Even for Bombay, there are so many cases coming from Pune, Nasik, same thing for Delhi, coming from other regions. I think now physical seat of the lawyers and legal advice is no longer, a big criteria to choose a lawyer, which means while it's an opportunity for people staying in different cities to do Bombay, Delhi cases, but it is also uh, in a way, opportunity for Bombay and Delhi lawyers to, look at Jaipur or, other places as well, where they used to not go because of the travel issues and stuff like that. So it's going to throw up a lot of different opportunities and threats as we go further. So coming to the last topic, and I think we are also coming to the close of our time, I know Kevin said in the beginning that we don't want to use two words, Brexit and COVID, but I think I don't end our session without discussing that. Also, there has been a bit of development in terms of other dispute-related issues, which Kevin mentioned about BITs and India unilaterally terminating some of those between 2016-17. While that is ongoing in terms of renegotiation, we did receive an award against India in the Vodafone, the famous Vodafone case in respect to retrospective taxation. Now, there has been some, noise from the government, I would say, which shows that they are concerned about agreeing to that award, which means there may be a situation where there might be a challenge or at least some kind of resistance as we go along. And of course, the other issues as we are seeing. But I want to bring in Nick here from a future perspective, right? Considering all these aspects, including COVID and Brexit, how do you see things progressing? Do you think it will create some hurdles or road bumps going forward, or all of this seems to be an opportunity, as we Indians always see in any problem? So, what's your take on that?
Thanks, Vyapak. Well, look, briefly, because one cannot not mention Brexit at the moment, as Kevin proved. I think the short answer for the UK-India disputes corridor is that Brexit is not going to make a great deal of difference, and not that most users will discern in terms of their use of London as a hub for India-related disputes. There is a question around the replacement of the intra-EU recognition and enforcement of court judgments currently governed by the Brussels regulation that will not apply when the UK leaves the EU. And just for those who aren't aware, the UK formally left the EU in January this year, but we're currently in a transition period where all the existing rules have remained in place. So if you haven't seen the difference yet, that's why. The talks are ongoing between the UK government and the EU. The transition period ends on 31st December this year, so it will happen in reality then, whether a deal has been agreed or not. Dispute resolution landscape, there is likely to be a replacement for the Brussels regulation. I think the UK government is trying to sign up to the Lugano Convention, which is a parallel and broadly similar recognition and enforcement regime for court judgments. There are some differences, but nothing that I think will be noticeable by most court users. Even if they don't sign up to that, will a French court suddenly decide not to recognise English court judgments and vice versa from 31st December this year? I doubt it. There has never been a recognition treaty enforced between London and New York courts, and people don't panic about judgments being enforced across those two jurisdictions. On arbitration, the impact will be nil, because, of course, the arbitration regime in the UK, the international enforcement recognition regime, as in India, is premised on the New York Convention, which as an international treaty will continue to be enforced and continue to govern recognition and enforcement of arbitration awards, whatever happens on Brexit. English courts will remain bound to recognise awards from Milan, Paris, Stockholm and elsewhere, and vice versa. So I think the role of London as an arbitration seat will be undiminished, and all the usual attractions that bring people here will continue to do so. On the treaties, Vyapak, yeah, interesting development, isn't it, from Kevin? And we'll watch that space closely to see whether a new investment treaty can be signed between the UK and India. These things don't tend to happen overnight, but the momentum towards it does sound encouraging. Certainly, I think the retrospective tax awards, as you say, we've had the Vodafone one. The next one probably will be in relation to Cairn Energy. And then there's an award to come as well in relation to Vedanta Resources. And I think, those awards are likely to make it more difficult, frankly, for the Indian government to embrace investment treaties in the future, or certainly will make it politically more challenging about what they want to carve out from those treaties. Obviously, we wait to see which way those decisions go. The Vodafone decision having gone against India in terms of a declaration that the tax is a breach of the international treaty, and so perhaps should not be collected inside India, is one that perhaps could be respected. There's a costs award that's also gone alongside that decision, which is not a huge amount of money, but is not insignificant. We wait to see what happens in the next two awards, because included in those, in the Cairn Energy award in particular, will be a decision on an award of damages against the Indian government, which is quite a large sum being claimed by Cairn Energy there. So if that award goes the same way as the Vodafone award, and there is a substantial award of damages against the Indian government, then I think that politically and legally will be very interesting for we watchers and techie lawyers, but also very challenging in terms of the future use of investment treaties between the UK and India. So it's a very hot topic. Watch this space, I think.
Sure. Thanks a lot. Thank you. And with those who are time to conclude this session, but any closing remarks from Wing or Kevin, if you have post hearing Nick and Karan, my other colleague, please feel free to add points on some of the topics that we discussed. Wing, Kevin.
Sorry, just it got cut off a bit whilst you were asking the question, so
I was just asking if you have any closing remarks or any points that you may want to add on the issue which Nick and Karan were talking about, adopting the new technologies or how the arbitration space is shaping up and so forth.
Just that again, business as usual. We're seeing now in arbitrations, in LCIA arbitrations and LCIA India arbitrations, and hopefully parties will find that the new rules are helping them to be able to resolve their disputes efficiently, despite this period of the pandemic that we're going through.
Sure, thanks a lot, and thanks Nick and Karan for joining and getting this session through. I think this was very, very helpful, and hopefully we will be able to see more business between the two countries and maybe even more disputes in that sense. So thanks a lot, and thank you for joining and supporting this webinar. Thank you, participants, for staying on and joining this very interesting topic and discussions around it. Thank you. Thank you, everyone.